An Advance Directive/Living Will Guide. Chapter 1. An Advance Directive Guide. Advance Directives Info. An advance directive is generally considered to be several documents or forms where you are covering your financial, legal, and medical affairs should you become incapacitated. The medical form is called the living will. When a person knows they might become seriously ill and be no longer able to make decisions about his or her healthcare, they fill out an advance directive designed to help ensure that healthcare decisions are consistent with his or her preferences. Advance directives may provide either general guidelines or specific instructions. The forms should be prepared and signed long before they are needed. Advance directive forms are available through hospitals' social service departments and from state or local medical societies and bar associations, or you can consult a lawyer to produce your own living will and durable power of attorney for healthcare. A living will is a document that indicates a person's wishes regarding life-sustaining medical treatments. A durable power of attorney for healthcare is a document in which a competent person gives another person, called a healthcare proxy, the power to make healthcare decisions for him or her. It goes into effect only in the event that the person is unable to make such decisions. The durable power of attorney can be withdrawn by the person who initiated it at any time. A do not resuscitate, DNR, order states that no one should perform heroic measures, including CPR and the use of mechanical life support equipment, to restart a person's heart should it stop. For your legal and financial affairs, get separate forms made out. The living will or a durable power of attorney for healthcare contains written instructions about your choices for healthcare or naming someone to make those choices for you. The instructions are to be used if you are too sick or otherwise unable to talk. Since 1991, the Patient Self-Determination Act requires that all federally funded medical facilities that accept Medicare and Medicaid inform patients of their rights to establish an advance directive if they want one. You do not have to have an advance directive, but if you have one, you can say yes in advance to treatment you want if you get too sick to talk to your healthcare provider. You can also say no in advance to treatment you don't want. Generally, if you are in the hospital undergoing surgery, you will be told about your right to accept or refuse medical or surgical treatment. Why leave these matters to chance? In studies where people asked what would their spouse, child, or parent want done if they were injured, in a coma, losing their mind, etc., over half the respondents were wrong. They didn't know what their loved one or really wanted done in these circumstances. If spouses, children, or siblings disagree over the patient's advance directives, the doctor will take over control and do whatever he deems best, which may not coincide with the patient's wishes. Quite often, an unconscious patient ends up on a respirator solely because the doctor is afraid that letting the person die might invite a lawsuit from the relatives. Doctors shouldn't have to bear the brunt of these tough decisions. Make up a living will and advance directive beforehand to absolve him of the duty and have it all spelled out crystal clear what to have done in the event they fall into tough medical situations. Once the patient's advance directive is completed, give a copy of the living will and medical power of attorney to your doctor along with phone numbers of your next of kin, lawyer, guardian and executor. Anytime you check into the hospital, hospice, or nursing home, bring copies of your advance directives and demand that they be put at the front of your medical chart. Do not resuscitate/DNR orders should be prominently placed throughout the chart for all the medical staff to see to leave no ambiguity about what to do in an emergency. Tell your guardians and attorneys to enforce your medical proxies if the medical staff don't carry them out for one reason or another. The primary physician is obligated to personally write any DNR orders and transmit them to the rest of the team. You're going to need his consent to disconnect or keep connected a respirator, feeding tube, or etc. If the doctor and family all agree on what to do, that's fine, but often there are ideological differences both within the family and between the doctor and the family about how to proceed medically in any given case. In order to resolve conflicts over the medical care of an unconscious or otherwise incompetent person, have a meeting with the family, primary doctor, lawyer, and priest all there to present your case to turn out the lights on your relative and let God take over. Bring a copy of the living will and medical power of attorney. A physician's refusal to honor a legal advance directive is grounds for firing him. It's fine to disagree on a subjective medical matter, but something else entirely to ignore the patient's explicit instructions or those of his representative. Some hospitals and medical professionals do not believe in taking patients off life support machines for one reason or another. You have to keep pushing to get what you want, even threaten to go to the media to get the right for your loved one to die in peace without medical technology. If the patient is medically stable and you are able to manage his care at home, you can refuse further treatment on the patient's behalf and have him discharged from the hospital to go home where he'll die in peace. You can complain to the State Department of Health. Patients and their healthcare proxies have an inherent legal right to refuse treatment and to make critical medical decisions regarding life and death. Your lawyer can petition a civil court judge to order a medical institution to abide by a legally binding advance directive or to appoint a guardian if no medical power of attorney exists, but it is still better to have it all done in advance. Laws governing advance directives vary from state to state. Your treatment choices will depend on what is legal in your state. You can ask healthcare professionals in your state about the state's rules for living wills or durable powers of attorney. You can also contact your local state's attorney's office for this information. Advance directives websites. The best explanations I've seen regarding advance directives was in caregiving books at either number 649.8 or RT61 at the library. Karingianfo.org, free advance directive information. AARP.org, 800-424-2277, booklet, Shape Your Healthcare Future with Healthcare Advance Directives. Abanet.org/aging/toolkit, Consumers Toolkit for Health Advance Planning. Agingwithdignity.org, 888-5 wishes. Choices.org, 800-989 will. Choicesbank.org. en.wikipedia.org/wiki/advance_health_directive. en.wikipedia.org/wiki/advanced_medical_directive. Finalizeit.org. Findlegalforms.com. livingwillonline.info. partingwishes.com, create and store your advance directives online. partnershipforcaring.org, 800-989-9455, end of life issues such as advance directives. ucihealth.com/advance_directive.htm. uslivingwillregistry.com/forms.shtm. National Academy of Elder Law Attorneys. 1604 North Country Club Road, Tucson, Arizona 85716. 520-881-4005. Fax, 520-325-7925. nalaw.org. Lawyers specializing in elder affairs like estates, wills, etc. Chapter 2. The Living Will. Losing one's mind/can't think for yourself. When you recognize that you or a loved one is slipping mentally, with the help of a trusted lawyer, grant a loved one a broad power of attorney and name them as a joint owner of all your property. If you don't, by the time you lose your mind, your main loved one will be forced to ask a judge to declare you legally incompetent and then try to convince the court to appoint him or her as conservator rather than anyone else who might want the title, like a business partner, other relative, etc. A conservator is allowed to handle an incompetent person's finances, whereas a court-appointed guardian has the power to make healthcare decisions for that person. When a court is petitioned to declare someone incompetent, the judge chooses a lawyer to act as temporary guardian. He or she oversees the affairs of the sick person until the matter is settled. The judge hears both sides and awards guardianship to whoever he or she believes will act in the patient's best interest. If you or someone you know is declining mentally, get the paperwork done now in order to avoid giving the court the power to make these decisions. The only way to avoid having a court decide your fate is to sign a power of attorney and healthcare proxy long before a crisis arises. Without it, your spouse, parents, partner or other loved ones could spend countless hours and dollars battling courts and each other to carry out what they think you would have wanted in the event of your death or a medical situation. You could lose your mind suddenly, as with a car accident, or you somehow take some poison. What you do right now is to make up a living will to tell people what to do in case you lose the ability to think on your own. Do it to save your loved ones a lot of heartache or court hassles. Your living will should consist of 3 parts. A durable power of attorney for someone to handle financial matters on your behalf. There are 2 types. A. An active one, such as one that couples get is active right now, so if something happens, your spouse has power of attorney. B. One that only goes into effect if you are incapacitated as certified by a doctor. Without this form, your people would have to petition a court for the right to handle things for you. 2. A healthcare proxy, or a durable power of attorney for healthcare, appoints someone to make medical decisions for you, such as if you want to be resuscitated if you have a medical emergency. 3. A living will defines what kinds of medical treatment you want or don't want. It's generally only valid if a person is terminally ill or in a persistent vegetative state. Healthcare proxies and living wills are often called advance directives. Find the forms at your local hospital, online or on the state government website. Medical incapacitation/living will. A living will is a legal document where you decree that others, your loved ones, will make medical decisions on your behalf should you become incapacitated in some way and unable to either think or think rationally with sound judgment. A medical proxy is a legal document where an individual states in advance what is to be done to him or her regarding medical treatment should he or she become incapacitated in some way. Proxies are created by signing a durable power of attorney for health care. The best way to deal with the prospect of medical incapacitation is to draft up a living will wherein you express your desires regarding life support in the event you are rendered unable to care for yourself due to medical or mental incapacitation. For one thing, medical life support treatment is expensive, and for another, it's harrowing for your loved ones to deal with a human vegetable, for lack of a better term. Also create a healthcare power of attorney or healthcare proxy giving someone else power over your financial and legal affairs in the case of incapacitation. These 2 legal documents together are called an advance directive, which covers you in all areas in case of medical or mental incapacitation. If you want, get a do not resuscitate/DNR order made up saying should you fall into a state of medical complications, you don't want excessive treatment. You want to be left to die naturally as it comes. All living wills are temporary and can be easily changed. They apply only to terminal illness, not if the person is just suffering but not terminal. A living will simply protects your right to refuse medical measures that prolong the dying process. It's a very simple form and doesn't even have to be filed with any government agency. It's probably best to get separate durable power of attorney forms drafted up for all 3 facets: legal, financial, medical. A lawyer can do it for you. As long as you're mentally competent, you can revoke it at any time. If you live with someone but are not married, you should consider getting these papers filed through a lawyer to give your common law lover rights over your care should something happen. Some bookstores sell these simple forms that you can fill out yourself. There are 2 types of durable power of attorney. Limited, where you grant another to take over certain responsibilities from you, like give them the ability to sign checks on your checking account. Springing means that you give someone else total control after you're unable to care for yourself. This is all controversial, but, increasingly, there are measures to alleviate suffering and let a person die with dignity without being subjected to an overwhelming array of artificial life-prolonging measures. In the end, it's your choice. Either live like a vegetable in pain or choose to die. Assisted suicide or merely termination of artificial life-prolonging devices is a tough call. Some people say it's a sin against God, but more and more people are going for it for one reason or another. You might want to check out some of the organizations listed below for more information. Do not resuscitate order/DNR. Do not resuscitate/DNR is an order either put into a living will by the patient in advance or by the patient himself in the hospital. He can tell the doctors treating him that if he starts to lose it, do not resuscitate. They might have him sign some papers. The next time there's an emergency on him, they don't make valiant attempts to save his life. They let him slip away. Chapter 3. Living Will Resources. Living Will Websites. uslivingwillregistry.com. living-wills-forms.com. 1stoplegal.com. 4trustsoftware.com. agingwithdignity.org. article_article_109781_18.html, information you need to know about your living will form. en.wikipedia.org/wiki/living_will. euthanasia.org/lwpdf.html. findlegalforms.com. lawdepot.com. lawworkshop.com. legacywriter.com. legalformsbank.biz/livingwill.asp. legalzoom.com/livingwilllegaldocument.html. living-trusts.net/will-kit.html. livingwill.com. livingwill.org.uk, Livingwill Britain. livingwillkit.net. livingwillkit.org. livingwillprep.com. livingwills.biz. livingwillsnow.com. livingwillsolutions.com. nalaw.org, Elder Law Attorneys. nalo.com, Legal Forms. Living Will Organizations. National Council for the Right to Die. Choice in Dying. 200 Varick St. 10th FL. NYC 10014. 212-366-5540. 800-989-9455. Choices.org. They sell Living Will kits. National Academy of Elder Law Attorneys. 655 North Alvernon Way. 108. Tucson, Arizona 85711. 520-881-4005. Fax, 520-325-85711. nalaw.org. Lawyers specializing in elder affairs like estates, wills, etc. Canadian Living Will Info. carp.ca. cbc.ca/news/background/wills. legalwills.ca. Living Will Form, Mail. Being of sound mind, do hereby willfully and voluntarily make known my desire that my life not be prolonged under any of the following conditions, and do hereby further declare. 1. If I should, at any time, have an incurable condition caused by any disease or illness, or by any accident or injury, and be determined by any two or more physicians to be in a terminal condition whereby the use of heroic measures or the application of life-sustaining procedures would only serve to delay the moment of my death, and where my attending physician has determined that my death is imminent, whether or not such heroic measures or life-sustaining measures are employed, I direct that such measures and procedures be withheld or withdrawn, and that I be permitted to die naturally. 2. In the event of my inability to give directions regarding the application of life-sustaining procedures or the use of heroic measures, it is my intention that this directive shall be honored by my family and physicians as my final expression of my right to refuse medical and surgical treatment, and my acceptance of the consequences of such refusal. 3. I am mentally, emotionally, and legally competent to make this directive, and I fully understand its import. 4. I reserve the right to revoke this directive at any time. 5. This directive shall remain in force until revoked. In witness whereof, I have hereto set my hand and seal this ____________ day of ______20 Declaration of Witnesses. The declarant is personally known to me, and I believe him to be of sound mind and emotionally and legally competent to make the herein content directive to physicians. I am not related to the declarant by blood or marriage, nor would I be entitled to any portion of the declarant's estate upon his decease, nor am I an attending physician of the declarant, nor an employee of the attending physician, nor an employee of a health care facility in which the declarant is a patient, nor a patient in a health care facility in which the declarant is a patient, nor am I a person who has any claim against any portion of the estate of the declarant upon his death. Living will form, female. I underscore 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 of underscore 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 being of sound mind, do hereby willfully and voluntarily make known my desire that my life not be prolonged under any of the following conditions, and do hereby further declare. 1. If I should, at any time, have an incurable condition caused by any disease or illness, or by any accident or injury, and be determined by any two or more physicians to be in a terminal condition whereby the use of heroic measures or the application of life-sustaining procedures would only serve to delay the moment of my death, and where my attending physician has determined that my death is imminent whether or not such heroic measures or life-sustaining measures are employed, I direct that such measures and procedures be withheld or withdrawn, and that I be permitted to die naturally. 2. In the event of my inability to give directions regarding the application of life-sustaining procedures or the use of heroic measures, it is my intention that this directive shall be honored by my family and physicians as my final expression of my right to refuse medical and surgical treatment and my acceptance of the consequences of such refusal. 3. If I have been diagnosed as pregnant and such diagnosis is known to my physicians, this directive shall have no force or effect during the course of my pregnancy. 4. I am mentally, emotionally, and legally competent to make this directive, and I fully understand its import. 5. I reserve the right to revoke this directive at any time. 6. This directive shall remain in force until revoked. In witness whereof, I have hereto set my hand and seal this day of underscore 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 20 underscore 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 underscore. Declaration of witnesses. The declarant is personally known to me, and I believe her to be of sound mind and emotionally and legally competent to make the herein contained directive to physicians. I am not related to the declarant by blood or marriage, nor would I be entitled to any portion of the declarant's estate upon her decease, nor am I an attending physician of the declarant, nor an employee of the attending physician, nor an employee of a health care facility in which the declarant is a patient, nor a patient in a health care facility in which the declarant is a patient, nor am I a person who has any claim against any portion of the estate of the declarant upon her death.